Let's dive right in. Welcome to the Explainer. Today, we're tackling something that is literally a monumental shift in the legal landscape down in Mexico. It's their brand new National Code of Civil and Family Procedures. And look, I know, a legal code sounds like some dry academic theory, but trust me, it's absolutely not. This document, it's essentially the new rulebook for the most impactful everyday life events you or anyone you know might actually face. We're talking the whole shebang. Going through a divorce, fighting for child support, sorting out a messy inheritance, or dealing with property disputes. It is completely rewriting the script on how everyday citizens interact with the justice system.
So, to make sense of all this, we're going to break it down into 4 quick parts. First, a new legal watershed. Then, guiding principles. Third, rules of the game. And finally, towards digital justice. Okay, part 1, a new legal watershed. Understanding the sheer scale of the change. To really grasp why this is such a watershed moment, you have to think about Mexico's historically fragmented legal system. I mean, the rules used to vary wildly from state to state. What worked in one jurisdiction could get you literally nowhere in another. But now, they've unified the entire thing into a staggering 1,191 articles. Yeah, 1,191. It's a massive volume, definitely heavy bedtime reading, right? But it really shows you the monumental scope here. They didn't just tweak a couple of outdated rules. They built a highly detailed, brand new engine for justice from the ground up, overriding all those old local and federal codes. The journey to get here actually kicked off back in 2017 with a mandate for constitutional reform, specifically targeting Articles 16, 17, and 73. And that finally culminated in congressional approval in April 2023. But here is the absolutely crucial detail: a 180-day maximum transition period. Once that timer starts, the federal government and individual states have a very strict 180-day window to adapt their local systems, upgrade their courts, and train their staff. The clock is officially ticking.
And you know what's driving this rush? It's a core philosophy straight out of Article 17 of the Constitution. It mandates that authorities must privilege the resolution of the conflict over procedural formalities. Basically, it's a brilliant directive that forces judges to focus on actual, real-world problem-solving instead of just getting bogged down processing endless paperwork. It's all about delivering actual justice, not just checking boxes.
Moving on to Section 2, Guiding Principles. The philosophy of a faster, fairer system.
Article 7 lays out a set of guiding principles designed to completely transform the courtroom into a dynamic, direct, and just way more equitable environment. We've got orality, meaning trials will happen out loud in spoken hearings rather than hiding behind mountains of written files. Then there's concentration, which forces judges to pack as much procedural action into a single hearing as humanly possible, just to speed things up. Equality ensures no discrimination, of course, and obviously the best interest of the child has to prevail over other conflicting rights. But there are 2 specific principles here that I really want us to zoom in on. First up is the gender perspective. Now, this isn't just some corporate buzzword, it's a hard legal requirement. It's defined as an analytical vision aimed at eliminating inequality and oppression. By baking this right into Article 7, the code actively forces judges to view cases through a lens that genuinely levels the playing field between men and women, ensuring equal rights and opportunities in both economic and social representation throughout the whole process. The second fascinating one is open litis, or litis abierta. Think about traditional law for a second. You're usually strictly bound by whatever exact wording you put in your initial lawsuit. But let's be real, family situations are messy. Life evolves. This principle means that in family matters, judges now have the flexibility to consider newly proven facts that pop up during the trial. They are empowered to seek the whole truth of an evolving situation rather than just having to turn a blind eye to a new reality simply because, well, it wasn't on the original intake form. Now, keeping things organized, Article 11 strictly classifies all legal actions into 3 main buckets. You've got real actions, which deal with property and assets, personal actions for obligations and contracts, and civil status actions covering major life events like marriage and divorce. Every single dispute is going to fall into one of those slices of life. All right, Section 3, Rules of the Game, how the new code works in practice. When you're hit with a legal issue, what's the very first, most immediate question you have? It's probably, which judge do I actually go to? In legal terms, this is called competencia jurisdiccional. It is heavily detailed in Article 89, and you've got to get it right. If you mess this up, your case can get thrown out entirely, so the new code makes these rules incredibly specific.
So, Article 89 assigns the right judge based on your specific situation. Let's say you're seeking a divorce. The code dictates you go to the judge in the location of your last marital domicile. Pretty straightforward. But what if you're a victim of domestic violence or you're seeking child support? The law actually empowers you here. You can file in your own domicile or the defendant's. It's entirely your choice. You don't have to travel halfway across the country to face an abuser or a negligent parent in their hometown. And for inheritance disputes, that defaults to the deceased's last domicile. It's a highly structured system, but it's specifically designed to protect the vulnerable. There's another massive practical change here, and it directly tackles backdoor corruption. Under the old practice, lawyers would often use what's called alegatos de oídas. That was basically whispering in the judge's ear during informal, one-sided private meetings to try and sway their opinion. Well, Article 134 shuts that down entirely. Now, any outside communication requires a formalized written request where both parties must be present. Zero exceptions. No more backdoor biases.
And finally, Section 4, Towards Digital Justice, Modernizing the Courts for the Future.
Look, writing new rules is great and all, but it isn't quite enough if the actual system is still stuck in the 19th century. Enter Article 933. It explicitly states that all procedures in this national code can be processed entirely online. And the crucial part, it mandates that this digital justice must be free of charge, equitable, and completely secure for the parties involved. Because true, modern justice means your access shouldn't be limited by where you live or by the cost of printing out thousands of pages of legal documents.
And we're already seeing how this digital framework seamlessly supports other modern legal needs, like class actions, which are outlined in Article 855. The steps for that are now highly streamlined. If a group identifies a collective issue, specifically things like consumer relations or environmental damage, they can file a class action so much more easily than before and process the whole thing efficiently using these new digital justice tools. It's a genuinely modernized workflow for a modern society.
Which leaves us with the ultimate question. Will this unified digital system finally close the access to justice gap in your state? We've explored the core principles, that strict 180-day transition timeline, the major push for transparency, and the leap into digital courts. The 1,191 articles of this new national code represent an incredible promise on paper, but now it's really up to the local courts to bring them to life. Thanks so much for joining me on this explainer. Definitely keep an eye on your local jurisdiction because the rules of the game have officially changed.